Okay, folks, let's get started. This is a criminal procedure video topic connected to the Miller and Wright Criminal Procedures, Prosecution and Adjudication Casebook. This is from Chapter 1, Subpart A1. We're talking about the availability of defense counsel, and in particular the types of charges that will trigger the obligation of the state to provide a defense lawyer. Now, this is an area where federal constitutional doctrine interacts with state statutory law and with state and local funding mechanisms. They're all really equally important here in the actual practices on the ground, but I'm not going to try to sketch that entire landscape for you. Instead, we're going to focus for now just on the federal constitutional part of the story, and in particular, I would like to spotlight for you three different moments in this developing history, really three vivid moments. Powell versus Alabama from 1932, Gideon versus Wainwright from 1963, and Shelton, or Alabama versus Shelton from 2002. So let's jump on into the Powell case. Now, the relevant constitutional text here comes from the Sixth Amendment. You see it quoted here. Notice the absolute language. It applies in all criminal prosecutions. The history here is set against an English backdrop where there were legal limitations on the availability of counsel, even retained counsel, for defendants who were charged with a felony. So the framers here were reacting to that English limitation and saying, no, if you can afford a lawyer, you can bring it into any kind of case. In Powell versus Alabama, 1932 case, the U.S. Supreme Court for the first time declared that the federal Constitution, the U.S. Constitution, had something to say to state criminal courts about whether they would have to provide counsel to criminal defendants. It grows out of really a cause célèbre from the 1930s, a famous, nationally famous case involving an incident at Scottsboro, Alabama. In March of 1931, 9 young black men were charged with the rape of 2 young women who were white. The incident happened or didn't happen on a train that arrived in Scottsboro, Alabama. When the train pulled in, accusations started flying and 9 people were arrested, became criminal defendants. In hastily arranged pretrial proceedings, the judge looked at the entire gathered bar, the defense bar of Scottsboro, Alabama, all there for this trial of the century, just there to watch. And the judge says, all of you are appointed to be lawyers for all of these defendants. Well, you can imagine how well that went. In that environment, for these private attorneys to have taken on these clients would have been commercial suicide. So nobody was really anxious to step up and do this. I picture this request from the judge operating a lot like an ancient tradition that we carried out at my wedding many decades ago now. You may know of this tradition. The groom will take a garter from the leg of his beloved bride, just as the bride will throw a bouquet over her shoulder, and the bridesmaids will fight one another to catch the bouquet to be the next to become married. The groom similarly will take the garter and will stretch it out, snap it over his shoulder. It will fly into the group of groomsmen who, in theory, will fight for the opportunity to catch the garter and be the next to be married. But among my friends who were groomsmen at the wedding, I turn, shoot the garter, and everybody just steps back and watches the garter land in a circle in the middle of the men, nobody willing to reach out and grab the garter. I picture these lawyers in Scottsboro the same way. The judge sends the appointment out into the courtroom, everybody steps back, watches it land on the floor in the middle of the circle, and nobody steps in to pick it up. None of these lawyers was going to step forward and represent these defendants. Ultimately, a lawyer from Tennessee, hired by interested parties, people who just heard about the case in the newspaper, hired this guy from Tennessee, comes in from out of town on a train, huffs and puffs into the courtroom just that day and says, I'm here to help. And the judge says, great, you're appointed, you're the main lawyer. And he says, wait a minute, I haven't met the clients, I'm not ready. And he says, no, today's the trial, go. So they had a trial. It resulted in conviction of 8 of the 9 defendants, but there is an appeal to the U.S. Supreme Court, and the basis of the appeal is, even though literally there was a lawyer standing there, this did not amount to representation by counsel, and under these circumstances, this is just a violation of fundamental fairness, and you can't have a conviction stand on this basis. After this first trial, the U.S. Supreme Court overturns the conviction and says that due process sometimes, in cases like this, requires counsel. This Supreme Court ruling in 1932, it all happened before selective incorporation really became the main way of understanding the content of due process. At this point, it was more about violations of a fundamental character, something that was contrary to the spirit of ordered liberty. And so the court says here that if you don't have a lawyer, it's the same as if you weren't heard at all. What is it that a lawyer would add exactly? I won't read the entire quote here to you, but the highlighted phrase really indicates that the court was mostly interested in accuracy. A defense attorney will be most valuable in those cases where an innocent person is charged. Notice all the different possible limitations built into the Powell opinion. These are facts in the case that the court mentioned. The court didn't explicitly say all of these are necessary to our holding, but the court did mention it, and in classic common law fashion, later courts were arguing about which of them were necessary to the holding and which were merely dicta. You see them indicated here. These were defendants who were not educated, who were illiterate, they were young, extreme public hostility. There was some serious risk of them being lynched for based on these charges. They were kept away from loved ones. Their friends and family were out of the state elsewhere. They faced the death penalty. Under all of these circumstances, the court said that you have to have a lawyer to avoid inaccuracy in a trial under these circumstances. And so after the Supreme Court's decision in 1932, you got to have a lawyer. It goes back for a retrial. On this retrial, some really interesting things happen. Samuel Leibowitz, now pictured here, is appointed, a famous New York lawyer, comes down to Alabama. Now it's become the case that rivets the national attention. Being presided over this time around by Judge James E. Horton, I think a legal hero. Judge Horton hears the evidence this time around and realizes, wait a minute, 2 key witnesses from the prosecution, one of them recants at the second trial and says, no, sorry, I made it all up. The other witness stuck to her story, but the physical examination of the complaining witnesses was not at all consistent with their story. So on that basis, the judge here declares, prosecution, you don't even have enough evidence to go to the jury. So the judge declares that there is inadequate evidence to go forward under the law of the day, is able both to take the case away from the jury, but also give the prosecution the right later on to retry these defendants. But by this mere declaration that there's insufficient evidence, he knows that his judicial career is over. He's an elected judge, and indeed in the next election, the voters of Alabama refused to return him to the bench. But he stood up for what he saw the evidence required, and so something of a partial success for attorney Leibowitz. After this second retrial in April of 1935, the U.S. Supreme Court again overturned the conviction of 2 of the defendants, Norris and Patterson, this time because state law excluded African Americans from the jury. Our second constitutional snapshot happens in 1963, the case of Clarence Earl Gideon versus Louis Wainwright. Clarence Earl Gideon, the defendant here, charged with burglary of a pool hall. Louis Wainwright, the warden of the prison. At the start of his criminal trial, Clarence Gideon asked for a lawyer, said, I deserve a lawyer. The United States Supreme Court says I'm entitled to be represented by counsel. Turns out he was overly optimistic in his reading of Supreme Court precedent. What was actually happening at that point was embodied in a case called Betts versus Brady, where over time the court had looked at Powell and other progeny of that case and had declared that under certain, quote, special circumstances, the state has an obligation to appoint an attorney, and the court over time had been working out what counts as a special circumstance. It can't just be any old case. You got to make some kind of showing that there's something special going on here to justify a lawyer. But what that special something was got to be less and less over the years. And so finally with Gideon, the court declared there doesn't have to be anything special going on. It's just all felonies. If it's a felony, the state has to appoint counsel. Now, according to the Gideon court, why is a lawyer important? This ruling really doesn't have a very deep basis in constitutional history or text. The court instead looks at precedent, the line of cases from Powell through Betts and beyond, talking about what the special circumstances are. And the court says, in addition to precedent, there's reason and reflection. And so there's a bit of a market-based argument here. Look, when people have money, they go out and get a lawyer. So that's one indication that they really add value. Lawyers are necessities, not luxuries, for anybody who has the means to go out and buy one, hire one. It's also kind of interesting that the court received some amicus briefs in this case from various states. Most states jumping in on the side of Gideon. Most of them already following this practice of appointing counsel in all felony cases. But a group of attorneys general led by Walter Mondale, pictured here, later the vice president, longtime senator from Minnesota, at that point the attorney general of Minnesota, put together a group of attorneys general who just said, for the sake of fairness, you need a lawyer in these cases. Interesting question, why the state count matters. You see this popping up in a few areas of constitutional jurisprudence, like the Eighth Amendment cruel and unusual punishment clause later on. But at any rate, the states helped frame for the court the practicalities of a ruling that would extend the right to counsel to all felony cases. Notice that the court's description of the value added by a lawyer is a little different here in Gideon than it was in Powell. In Powell, it was all about accuracy. In Gideon, it's just more that you can't imagine a trial that counts as a criminal trial if you don't have a defense lawyer there. Just as it's not really a trial if there's no judge in the room or if there's no prosecutor in the room. It's just part of the furniture. It's just part of what makes a trial a trial. It is a necessity, not a luxury. Anybody who can hires a lawyer. When the government wants to go forward with criminal cases, they hire a lawyer. It's just, you build a courthouse, you hire the judge, you hire lawyers on both sides. Despite this lack of emphasis on accuracy, on remand in the second trial, Gideon did get a lawyer who did a darn good job of investigating the case pre-trial, found some real trouble spots in the prosecution's case, and ultimately was able to generate an acquittal from the jury in the second trial, as famously recounted in Anthony Lewis's famous Gideon's Trumpet book, recounting the Supreme Court litigation and its aftermath. Finally, our third constitutional snapshot here comes from 2002, Alabama versus Shelton. In this case, you've got a defendant who's convicted of third-degree assault, which is a misdemeanor. Now, at this point, we have some post-Gideon case law that was relevant to Shelton's case. In the post-Gideon case law, like in Argersinger and Scott, the court had embraced something called the actual imprisonment rule that said that if a defendant faces charges that ultimately do result in the imposition of a prison term sentence, not just a crime punishable by prison, but this defendant was actually punished with prison, then that conviction can only be legitimate, can only be constitutional, if an attorney was representing the defendant. So it's called the actual imprisonment rule. Shelton says the actual imprisonment rule should also apply to me even though I'm not sitting in prison. Because Shelton says, this is a misdemeanor. I was sentenced to a suspended term. I was threatened with prison if I don't carry through with my obligation to pay court costs, a $500 fine, $569 in restitution, and $25 in reparations. So if I don't carry that sentence out, then the judge might activate my suspended sentence and I might ultimately end up in prison. The state of Alabama disagrees and says, as long as you're not actually sitting in prison, this kind of sentence is okay. It's okay for the judge to threaten a prison sentence as long as it remains suspended and not actually carried out. The Supreme Court agrees with Shelton here and says, as the language on the screen indicates, that any sentence that may end up in the actual deprivation of a person's liberty can't be imposed without counsel. So these suspended sentences now count. One important thing about Shelton is that it expands the base of a pyramid. So if the number of cases affected by, say, the Powell ruling or later on the Betts ruling would have been the top of a pyramid, the most serious cases, but not so many of those cases, and then a larger base of cases are covered by Gideon as you move down the pyramid. We're now covering not just all the felonies, but some of the misdemeanors, the ones not only that result in actual imprisonment, but the ones that may end up in the deprivation of the defendant's liberty. So we're expanding the range of cases where the state has some obligation to provide counsel and therefore expanding the costs. Reflect finally on how this rule gets applied. As if you imagine yourself to be the judge. You're at the start of the case. The defendant comes in and faces charges that are punishable by prison, but you don't yet know whether you're going to impose that sentence or not. If you want to hold open your options, if you want the possibility of a prison sentence later on, you have to appoint a lawyer up on the front end of the case to keep your options open. And so this ruling requires something of a prediction and of a playing it safe decision by the judge. That's done with one eye. On the other hand, the judge keeps one other eye on the funds available to pay for lawyers. So we've covered the three high points in the Supreme Court's recent jurisprudence on the availability of state-appointed counsel. Now that we've covered those constitutional contours, the next time we get together, we will be talking about how that law interacts with the equally important state statutory provisions and state and local funding mechanisms that all interact to produce availability of counsel. So that process of integrating different sources of law will occupy us the next time we get together. See you then.